Mr. Murali.
Mr. Deputy Speaker, sir, I declare my interest as a practicing lawyer and an assigned solicitor with the Legal Aid Bureau. I welcome these landmark amendments proposed to the Legal Aid and Advice Act, which comes 62 years after the enactment of the original bill. The raison d'etre behind the bill when it was moved by the then Minister for Labour, Mr. Lim Yew Hock, in 1956, remains the same. This point was put across eloquently by the Honourable Minister, Ms. Indrani Raja, in this House in 2013, when she said, access to justice is one of the cornerstones of our society. We may have the best laws, the best courts, and the best system, but all that would be lost if they cannot be accessed by persons in need. Like all things, there's a cost to legal services, and not everyone can afford such services. It was with this in mind that the Legal Aid and Advice Act was originally enacted in 1956 to ensure access to justice. That objective remains relevant today as it was then, unquote. We just heard the Senior Minister of State, Mr. Edwin Tong, subscribing fully to this statement, and Honourable Member Mr. Abbas Ali also echoed a similar point. When the Legal Aid Bureau was established pursuant to the Act on 1st July 1958, Singapore became the first country in Southeast Asia to have such a legal aid scheme. Currently, the Legal Aid Bureau, which sees over 9,000 applications for legal aid annually, it celebrates its 60th anniversary this year. It's timely that we review our legal aid scheme to ensure that we keep abreast with changes to our society. A key reform in the bill is the changes to the means test to be used to assess eligibility for legal aid. I recognize that it is not easy to fix a fair and equitable means test that is totally immune to criticism. The new means criteria of per capita household income is commendable, as it allows more flexibility in the assessment of means to take into account the overall income situation of the household and not the applicant's individual situation, which may not be reflective of his or her situation. Let me give you an example. Last month, I filed a parliamentary question arising from a case. It concerned a legal aid application made by a father seeking assistance to be appointed as a deputy of his mentally disabled son. I asked, why is it that the father was treated as the applicant as opposed to the son? Ordinarily, his son would have been eligible for legal aid, but he cannot apply because he is not mentally capable. The application for deputyship and legal aid was made by the father. The application, after all, was for the benefit of the son, and it was meant to facilitate the care and management of his son. Unfortunately, the father was deemed not eligible for legal aid, as the current means test only looks at his circumstances as an individual and not that of his son. Under the Act, the Director of Legal Aid may exercise discretion to exclude up to $30,000 to determine the disposable capital of the applicant if the applicant is suffering from mental disability, a point that the learned Senior Minister of State just made. But here, this ground cannot be raised because as far as the Legal Aid Bureau is concerned, the applicant is a father who is mentally sound. So one wonders when this proviso can apply, because ordinarily one assumes that applicants must be compos mentis. In his reply, the learned Minister for Law stated as follows: it is not possible for legal aid applications to be made for or on behalf of the mentally incapacitated person and then use that person's means to support the legal aid application. In my respectful view, such an approach may operate unfairly against the family as it did not adequately take into account the circumstances surrounding the mentally incapacitated son and the reason for the application in court in the first place. I'm glad to, however, note that if this bill is passed, then this issue will be taken care of, because the PCHI will be adopted as a means test. Both the income of the father and the son will be taken into account to assess the father's means more holistically. The Legal Aid Bureau will be also vested with powers to exercise greater flexibility to provide targeted help to applicants in extenuating circumstances. The means test must be flexible enough to remain relevant even when there are ups and downs in Singapore's in Singapore's economic growth. In terms of the qualifying limit for the new PCHI means criteria, which I understand will be set later in subsidiary legislation, after taking into account the latest income data, could the Honourable Senior Minister of State please elaborate what are the considerations that will be inputted in relation to setting the limit? For example, would it be based on the 20th percentile of the PCHI? Would the income limit exclude CPF contributions, a point that the Honourable Member of Parliament, Mr. Gan Thiam Poh, mentioned? This should be the case, in my respectful view, because it should take into account actual disposable income. How about circumstances where families are put into significant expense? And I believe the Senior Minister of State mentioned that this will be taken into account. What will be the principles governing such assessment? Apart from the new means test, the bill now provides that the Minister may direct the Director of Legal Aid to issue a grant of aid, even though the Director is of the opinion that the applicant does not satisfy the prescribed means criteria. If the Minister is of the opinion that it's just and proper for legal aid to be granted. May I clarify, does this operate as an appeal to the Minister by the applicant who has been refused a grant of aid by the Director? And this is presumably so because the Directors would have already made an assessment of eligibility at the first instance. If so, would the Minister require the Director to provide grounds for his decision, and would such grounds be provided to the applicant so that the applicant can comment on it in his appeal to the Minister? And what are the circumstances that is contemplated where it would be just and proper for the Minister to grant legal aid? May I also please ask, what's the outcome of the suggestion that was made in this House by the Honourable former Member of Parliament, Mr. Hari Kumar, when the Act was last amended in 2013, when he suggested to Minister Indrani Raja that the government, through this Act, introduce a public defender scheme, drawing from the private sector to help indigent citizens who face criminal proceedings. At that point in time, I read the Hansard, and it was indicated that the Ministry would consider the suggestion. I'd be grateful for an update, please. Finally, the explanatory notes of the bill state that the bill will not involve the government in any extra financial expenditure. I'll be grateful for a clarification on this statement. I note that Ministry of Law has stated that the qualifying limit for the PCHI test will be set such that there will be no material impact on the number of households who are eligible for legal aid. However, there will presumably be some increase in eligible cases given the shift from individual-based criteria to household-based criteria. Would there not be a need for additional resources to be provided to the Legal Aid Bureau to deal with this? Now, I will now conclude. Over 60 years, the views expressed in this House is consistently that justice must be accessible to all. The Act has been reviewed regularly over the years to ensure this goal. I support the amendment bill for its progressive changes made in the way that we assess means eligibility for legal aid to ensure that justice remains accessible by all. Thank you.